All right, Ms. Hewitt. This time, what's the case number, Patty? 656361? No, wrong number. Give me the case number, Patty.
667912.
All right. Court calls 667912, State of Texas versus Celestino Serna. Mr. Serna, would you raise your right hand?
Yes, sir.
You solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
Thank you. Put your hand down, please. Mr. Serna, before we proceed, I need to make a record of a verbal record that is being taken down by my court reporter, Ms. Kayleen Rivera. It is an official public record. I need to remind you that you have certain particular. First of all, you have the right to remain silent. That means that you don't have to make any kind of statement. You don't have to answer questions. You don't have to submit written papers that have your signature, especially papers that have admission or confession to wrongdoing. Do you understand? You have the right to remain silent.
Yes, sir.
You have the right to a jury trial. That means that you and your attorney and the state could select 6 people from a jury pool of disinterested citizens who would hear the evidence or watch the whole trial and decide whether you're not guilty or whether you've been proven guilty beyond reasonable doubt. That's called the right to a jury trial. You know, you have that right.
Yes, sir.
If you go to a jury trial, people would come in and testify. And you and your attorney would have the right to question, cross-examine, and challenge any witness who would testify. That's called the right to confront witnesses. You understand you have that right.
Yes, sir.
There's also a right that is hard to do, but you or your attorney or the two of you could do it. That is the right to appeal. That means you would demand in a proper form and substance, demand the right to have a higher court review the official record and the evidence in this case and the result and decide any kind of legal challenge that you might make. You'd have to obey the need for the proper form and substance and time limitations, among other things. You understand you have the right to appeal.
Yes, sir.
Finally,
Hey, Judge, there's something went wrong with your audio and your video. I'm having a hard time understanding everything you're saying. Can you check it, please?
sure. Can you hear me? Microphone has changed. That changed to microphone USB 2.0 camera. Okay. Can you hear me?
Yes, sir.
All right. Mr. Sedna, you also have a right to demand that this proceeding be held in the open public courtroom.
Mhm.
The state has that right also. So there's 2 sides that have the right to demand an open public courtroom. Because of the pandemic, we're not doing that. But in order to proceed, you and the state have to consent to have this hearing by video conference, which is what we're doing right now. You understand that's what you're doing and that you have to consent to it.
Yes, sir.
Now, you have reviewed different forms, written forms, documents with your attorney, and you have signed them. The documents that you signed, did you understand them?
Yes, sir.
Did you review them with your attorney and ask any questions that needed to be asked?
Yes, sir.
All right. First of all, you did sign a consent to video conference, is that correct?
Yes, sir.
Ms. Hewitt, the documents that bear your client's signature that are part of the record are being made part of the record. Did you review them with him and counsel him on them?
Yes, Judge.
Did he have any questions or doubts?
No,
Did you, in fact, sign a document wherein you attest that the state has complied with Article 39.14 Texas Code of Criminal Procedure in that it complies, the state complied with discovery?
that's correct, Judge.
All right. Now, Mr. Sedna, there's a document. It's extensive. It's called Defendant's Waiver of Constitutional Rights in Court's Admonitions. That document talks about what you're charged with, how you're pleading. It also had 15 numbered parts that, among other things, reviewed in writing the rights that you have and that you have been informed of. It also had a portion in there that said that you know and understand that the deal that you've made with the state is not binding on me as a judge. As a judge, I have the requirement, the authority and responsibility to say, yes, I accept your deal, or no, I do not accept it. I also have the authority to give you any punishment in the range of punishment for the offense with which you're charged. The range of punishment in this case, I understand, is a Class B punishment. Is that correct, or am I wrong?
Yes, sir.
That's
Ms. Hewitt?
correct. Yes,
Okay.
Judge.
That means it is a fine from $0 to $2,000 and jail from 0 days to 180 days. Now, do you understand that I don't have to accept any kind of deal?
Yes, sir.
Also, if I choose to, I can give you any punishment within the range of punishment, even if it's heavier than what you agreed to. If I reject your deal or give you a punishment that's heavier than what you agreed to, then in that case, the law would allow you to start all over again if you chose to, and nothing that you've said or signed up till now would be used against you. Is that clear?
Yes, sir.
All right. Now, there's also a document called a plea agreement. That one has in detail what you've agreed to. Did you review the plea agreement with your attorney and sign it?
Yes, sir.
All right. Is this on today's docket, Patty?
It was, Judge.
What's the case number?
667-912.
Judge?
All right. Yes, ma'am.
Okay.
Yes.
It was on page 7.
Yes, ma'am. I found that out the hard way. On 667-912, to the charge of racing on a highway, Mr. Sedna, how do you plead?
No content.
You understand that a no contest plea is considered a guilty plea in this court and is sufficient for me to convict you.
Yes, sir.
All right. Now, state, what is he pleading to? I know it's racing on a highway, but
Yes, Judge.
and is he applying for probation?
Deferred, yes, Judge.
All right, so there's an agreement for deferred. Mr. Sedna, to make sure you know and understand, a deferred adjudication is a special form, a beneficial form of community supervision, also called basically probation. That means that if you live to 100% of the conditions of supervision, you will not be convicted. If you fail to live up to 100% of the conditions of supervision, then the state may ask me to give you official notice, bring you in for a hearing. And at that time, if the evidence supports it, I can make a choice to go ahead and give you a final conviction. Living up to 100% means the case will be dismissed and you're not convicted. I will not enter a finding of guilt. If I have to do a hearing and go ahead and enter a finding of guilt and convict you, then I can look at the entire range of punishment, $0 to $2,000 fine, and jail from $0 all the way to, jail from 0 days all the way to 180 days. Is that clear?
Yes, sir.
The conditions of supervision will be read to you by the probation department, and you will sign them, and you will have a copy in your hands. Is that clear?
Yes, sir.
All right. To the charge, you have pled no contest. I find there is sufficient evidence to find you guilty, but I do not find you guilty. I am granting you deferred adjudication. State, recite for the record, for how long will the deferred adjudication be?
6 months,
6 months deferred.
a $500 fine, plus court costs. 24 community service hours. MRT. And we're going to take into consideration case number 626059.
Ms. Hewitt, is that the understanding you have?
It is.
Mr. Sedna, is that the understanding you have?
Yes, sir.
All right, I approve the agreement. You're granted 6 months deferred adjudication. You're fined $500 plus court costs, 24 community service hours restitution. You will do the MRT. Define that for me, Ms. Pollard.
I'm sorry, Judge, what was that?
The MRT, define that for me for the record.
It's a course that's focused on helping younger people make better decisions.
I think it's more moral recognition or
Moral-
something
yeah.
like that.
All right. You understand what that is, Mr. Sedna?
Yes, sir.
All right, that's what you're going to be required to do. The court will
Okay.
take in consideration the case number 626059. That case is dismissed as part of this plea. Your supervisory fee will be $29 a month.
Okay.
Now, do you believe that you can afford to make that $500 fine?
Throughout the 6 months, yes, sir.
All right. Then we'll stay with that $500 fine. Any questions, Mr. Sedna?
Yes. I got 2 questions.
I'm listening.
On the court, you said I was gonna have to pay court fines, right?
Court cost.
Court cards. What is that?
Ms. Garcia, can you tell him what the court cost will be?
The clerks are gonna tell him how much the total is, Judge, because they have to add on the booking and all of that.
All right. That'll be several $100s, but you'll have the 6 months to cover it. I have made the supervisory fee somewhat minimal. The absolute minimum is $25 a month. I made yours $29.
Okay.
You are also ordered to go to the offices of County Court at Law Number 5. They're behind the main courtroom.
Mhm.
And there you're to have your thumbprint placed on the documents as required by law. Is that understood?
Yes, sir.
All right. Any other question? You had 2 questions. What's the other one?
Yeah, on the community service, where do I, like, if I want to do community, where do I go to do that?
All right, you, before you leave today, you will be placed in breakout room with Maricela Luna. She
Mhm.
is what's called a court liaison officer. She's going to start you off on the probation path. She'll put you on there, and with that, you will be informed of the details of how you're going to be put on probation, what you're going to have to do. They will read the conditions to you, all of that kind of stuff. You
Okay,
understand? Don't leave this meeting until you've met with Ms. Luna.
okay.
All right?
All right, that sounds good.
Any other questions?
No, sir.
If you have questions, you be sure and ask your probation officers, okay?
Okay,
They're there to help you.
okay.
Ms. Hewitt, any questions?
No, Your Honor.
And Ms. Pollard, any questions?
No, Judge.
All right. Thank you, my ladies. Thank you, gentlemen. I think that takes care of the